mouth today. I'm the president of the Federalist Society, and my friend and section mate Kevin here is the president of ACS. Everybody wave at Kevin. Okay, so we thought, the immigration ban, the travel ban has obviously been a big topic, although it's been seemingly moot at points, I guess, along the way. They're going to tell us more about that. It's still very much an issue in contention. And so with that being said, on behalf of the Federalist Society, I would like to introduce Professor Josh Blackman right here. Just give a little bit of background on Professor Blackman. He's a professor just from about 5 minutes down the road at South Texas.
The other law school in Houston, we don't speak of that here.
He's actually been on the 30 under 30 list for Forbes Law and Public Policy. He's testified, I believe, twice over executive action on immigration in front of the House Judiciary Committee, as well as a host of other accomplishments. And so with that being said, I will let Kevin take over from here.
Cool. And as the president of the American Constitution Society, I'm here to introduce Professor Jay Iyer. Many of you might know So many of you might know him. He hosts a weekly podcast called Party Politics on the Houston Public Media. It's probably awesome. If none of you have had a chance to listen, I definitely recommend it.
Please do listen.
So he has his bachelor's degree from the University of Texas at Austin in government and economics, I believe. He has a master's degree from the exact same establishment, and he graduated from South Texas College of Law in 1995. So currently, on top of working with this podcast, he's also still an adjunct professor at South Texas College of Law. So without further ado, we're going to kind of do this pretty basically. Professor Blackman's going to begin, speak for about 25 minutes, and then we're going to have a chance for Professor Iyer to respond, and then we'll take a couple questions from the audience. Hopefully we'll have them. Thank you.
Thank you. It's a pleasure to be here at U of H. Neither of us are actually from U of H, but we're happy to speak to you today. I always enjoy Federal Society and ACS co-hosted events when you have two people on different sides of an issue, you can have a civil debate, civil dialogue. It's something that more people should do today. So our topic today is travel ban. But before I get to that case, I'd like to discuss another case that you may have studied in constitutional law. This is a case called Texas versus Johnson. This case considered whether a person can be arrested for burning an American flag at a political protest. It was actually in Dallas, of all places. Now, this decision, you may recall, broke down on 5-4 lines. But to the surprise of many, Justice Scalia voted for the flag burning. Now, Justice Scalia was no fan of flag burnings. He once said, if it were up to me, I would put in jail every sandal-wearing, scruffy-bearded weirdo who burns the American flag. But I'm not king, Scalia said. Scalia felt the answer was compelled by the Constitution, even though he disagreed with the result. Texas versus Johnson is a good gut check for lawyers and law students. If your understanding of constitutional law overlaps entirely with your own philosophical beliefs, you may want to reassess the former. This is much how I feel about the travel ban. I'm a libertarian. I generally favor open immigration policies. I think the idea of banning people from entering the country from certain nations merely because those countries have been associated with terrorism is an awful policy. I believe that. I think these executive orders will cause hardship to families, refugees, and others seeking a better way of life. I'm also doubtful these policies will do much to improve our national security. Yet, with my cards on the table, I am convinced that Congress gave the President the power to take these actions, and I'm also convinced that the Constitution does not bar him from exercising the powers in the manner in which he did. So in my time today, I want to hit 5 points. First, I want to walk you through a history of the travel bans, going all the way back to statements made by then candidate Trump, and also statements made by now President Trump. Second, I want to discuss the contents of the 3 executive orders, which have been halted by the courts, all of them. Third, I will discuss whether Congress has given the President the power, from a separation of powers perspective, to take these actions. Fourth, I want to discuss whether these actions conflict with the First Amendment, the Establishment Clause. And lastly, I want to give you a preview of what I think the Supreme Court will do when it eventually gets around here to this case. So our story begins way back in December 2015, long before anyone knew that Donald Trump would be president. At the time, Trump called for, quote, a total and complete shutdown of Muslims entering the United States until our country's representatives can figure out what is going on. Over the next few months, Trump shifted his position from the so-called Muslim ban to a move of extreme vetting from people from certain territories. Or did he change his position? During an interview on 60 Minutes, Trump told Leslie Stahl that she can still call it whatever she wants, but we'll call it territories. Was this a repudiation, or was it just a wink and a nod to the alt-right? However, a week later on Meet the Press, Trump seemed to repudiate it. He said, I'm talking territories instead of Muslim. Now, that's not a complete sentence. I don't really know even what that means, but he seemed to abandon his position, or maybe he didn't. Fast forward to the inauguration. January 20th, the president sworn into office. A week later, on January 27th, President Trump issues the first travel ban, which I will call Executive Order 1.0. What did this order do? For 90 days, aliens from Iraq, Iran, Libya, Somalia, Sudan, Syria, and Yemen, 7 countries, were deemed detrimental to American interests, and they will be denied entry into the United States. And then for 120 days, the refugee admission program will be suspended. Syrian refugees, in particular, will be denied entry indefinitely. So almost immediately after the order was signed, airport officials began to detain nationals arriving. And this was absolute chaos. Think about it. When a person got on a plane overseas, their paperwork was in order. As they were crossing the Atlantic or the Pacific, this order came out. So by the time they landed, they were no longer allowed to enter. Judges issued what were called writs of habeas corpus, these emergency orders, saying you have to release these people from captivity. You may not know this, but when you're at the airport, in the customs area, you're not on U.S. soil. You're not. Until you actually clear customs, you're in this weird middle region. But this was only the beginning of the lawfare. Shortly thereafter, the state of Washington challenged the constitutionality of this first executive order. A federal judge in Seattle issued a global injunction barring the enforcement of this order, and the Ninth Circuit Court of Appeals affirmed that order. The government started rehearing en banc. It was denied over several dissents. At that point, the government could have gone to the Supreme Court. They didn't. They said, okay, we'll try again. Fast forward to March 6, 2017, President Trump signs the second executive order on immigration. A couple big changes. First, it removed Iraq from the list, also made clear that green card holders were not subject to the policy. Okay? It also shifted the justification. Instead of arguing that people from these countries made themselves be dangerous, which I think was always the wrong question, the new order said that these countries lack sufficient diplomatic relations with the United States so that we can't trust their screening mechanisms. A number of these countries are state sponsors of terror. Some of them just don't share counterterrorism information with us. Surprise, surprise, version 2.0 was challenged in court, and federal judges in Maryland and Hawaii issued global injunctions barring their enforcement on different grounds. So as affirmed by the Fourth Circuit Court of Appeals, the court said that this order violates the Establishment Clause. The Ninth Circuit took a slightly different approach. They said that the president lacked the statutory authority to deny entry to these aliens. I'll discuss both of those positions a little bit later. Okay, so the second order was enjoined. Following them were several trips up to the Supreme Court, where the Supreme Court argued about who was a close enough family member to be allowed in while this appeal was pending. Was grandma close enough? Was grandma close enough? All of this stuff, this back and forth, eventually as grandma was a good enough relative, didn't amount to much. Why? On September 24th, roughly a month ago, we get version 3.0. This was the final proclamation. And the order had a couple changes. So first, the order said that we've now done this global review of our relations with countries around the world, and we've established what they call a security baseline. That is, if you want your people to come to this country, you have to share certain information. And after this review, the Secretary determined that 8 countries were deficient. Who are these countries? Chad, Iran, Libya, North Korea, Syria, Venezuela, and Yemen. Now, a couple new members are on that list. We have added North Korea, we've added Venezuela, we've added Chad. Dropping from the list is Sudan. Okay, Now, as you could probably guess, there are not many North Koreans entering the United States. Rocket Man doesn't have a very big tourism policy in this country. As people basically prisoners, so they can't come here. So there's not much going with North Korea. Venezuela, unfortunately, Jose Altuve can stay here. God bless Jose, right? Topical humor, right? So fortunately, Venezuelans are allowed. The policy applies only to a small number of diplomatic officials. The only real new country of any merit is Chad. You may not know this, but Chad is a majority Muslim nation in Africa. So we still have the same issue. Sudan, which was on the list, now is off the list. They've shared information. Now, this is not a permanent policy. I'll call it quasi-permanent, because it says every 6 months review to see if a country comes off the list or on the list. So I am fairly safe in saying that Iran will never come off this list, Syria will never come off this list, Libya will probably never come off the list. Maybe Yemen could, but in theory, probably not. Surprise, surprise, version 3.0 was challenged. And about a week ago, federal judges, again in Maryland, Hawaii, the same judges, issued another round of global injunctions. The judge in Hawaii said that, again, this violates the president's statutory authority. And the judge in Maryland, again, said that we have an establishment clause violation. So even though we have different incarnations of the order, we're basically the same exact spot, right? First, does the president have the statutory authority to do this? And second, do these actions violate the federal constitution? And that's what I want to give the rest of my talk. It took 10 minutes just to explain the posture of this case. It keeps getting longer and longer. So let's start the statute. 8 U.S.C. 1182F provides that whenever the president finds that the entry of any aliens or any class of aliens into the United States will be detrimental to the interests of the United States, he may make a proclamation, and for such periods as he shall deem necessary, suspend the entry of all aliens or any class of aliens, blah, 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 blah. Okay. So that's a fairly broad delegation of power. That when the president determines that a class of aliens would be detrimental to American interests, he can deny their entry. Okay, so the question is, what does this provision mean? This has been used by presidents going all the way back, Reagan, Carter, to basically block entry to entire classes of aliens. President Clinton used it to deny access to Haitians. President Reagan used it to deny access to Cubans. There were a usage by President Carter to deny access to Iranians. Right? This has been used on a fairly broad basis. And it's never been argued that this was a violation of the statute. Now, what do the plaintiffs say here? To make this determination of detrimentality, the president must put forward specific findings to show why these people are dangerous. Maybe that's a plausible reading of the statute, but no president has ever been forced to do that before. Okay. So that's the first statutory component. The second statutory component concerns visas. The big 1965 Immigration and Nationality Act is a very important legislation. It says that with respect to the issuance of visas, the government cannot discriminate on the basis of nationality. This was designed to eliminate the quota system, right? Where certain European nations got lots of visas and other countries that were not so popular got fewer visas. That is out the window. The argument here is this. Can the president use nationality, these 6 countries or 7 countries, as a basis for denying visas? So I think there's 2 ways of reading this, right? So first, there are no suspension of visas. If you have a visa, if you like your visa, you can keep your visa, right? Under this policy, you can keep the visa you have. But it is true that certain people applying for visas will be denied. And I think you can make the argument that denying visas under this policy amounts to a form of nationality-based discrimination. But there's another aspect of the statute which says the secretary can make exceptions to this. And I think in order to avoid some really serious Article 2 problems, right, where you're infringing on the commander-in-chief's powers, you have to read the statute to allow carve-outs for nationality-based decisions. I think you can read the statute otherwise, but that would create significant problems. That's the statutory component. But what you're all here for, of course, is the constitutional component. No one cares about statutes in law school. It's true they don't. The First Amendment. So let's start with the Establishment Clause, right? Usually when you think of the Establishment Clause, you think of cases like, building a 10 Commandments display in the courthouse, right? Or prayer in school, or, a creche inside of a city hall, right? That's the usual case you think of. This case doesn't really fit into that mold. What the argument here is not that the government's trying to establish a 10 Commandments monument, right, or establish a church. They're saying that by instituting this policy, the government is showing a disfavor of Islam. That is, by favoring Christian refugees and by favoring Christians in immigration policy, there's a disfavor of Islam. And that's reflected in the sorts of statements President Trump made both before the inauguration and after the inauguration, right? That we have to have a complete shutdown on Muslim immigration. I read you all those statements before. So this question, though, is a little bit more complicated than you may think at first glance. There's a threshold question that the courts have never addressed. Does the Establishment Clause apply to immigration law? I think, of course the judge, right? It's wishful thinking, right? Of course Josh does. Why wouldn't it apply? There's some good reason to think it doesn't. So I'll give you a few examples, right? We have immigration statutes in the book that say if you are a Soviet Jew or evangelical Christian, that's what it says, Soviet Jew or evangelical Christian, you are given preference for receiving visas. Whoa, right? If that statute is subject to Establishment Clause scrutiny, it's really unconstitutional. But it's been in the books for 30 years and no one's ever challenged it. We have another statute that's even older that says if you are a full-time minister, you get preference for receiving a visa. Now, what's a full-time minister? Here's examples. Priests, nuns, brothers, sisters, right? Monks. If you're a part-time Episcopalian minister, you may not get it. This sort of statute and regulations are very much entangled with religion. No one's ever doubted these laws were valid. Think of asylum law, right? If you want to show a credible fear of persecution, you have to make some very specific determinations about a person's faith. These sorts of things would never fly in domestic court. So I think there's a fairly good reason to think the Establishment Clause simply doesn't apply to these sorts of immigration decisions. But maybe I'm wrong, right? Let's assume I'm wrong. Let's say it does apply. What sort of evidence can we consider to show that this policy, which especially 3.0 is facially neutral, has an impermissible purpose? Well, we have statements from before the inauguration and statements from after the inauguration. And I think you have to separate, you have to split these two up. The statements from before the inauguration are pretty bad. I'm not closing my eyes to them, I see them, they're right there. But there's zero precedent for the fact that you look to statements made on the campaign trail to inform the president's decisions. There's just no precedent for that whatsoever. Trump came to office. So maybe the Supreme Court will say, yes, these statements are fair game. I don't think they're going to go down that road. I actually view the inauguration, the taking of the oath, as like a baptism where it cleanses you. Maybe for Trump it worked or not, I don't know. But this is a very significant moment. You took the oath, you formed the government, and I think stuff before that is off limits. Now, I think statements after inauguration are fair game. I actually do, and I've been writing about this for some years. The problem for the plaintiffs is the stuff after inauguration is a lot more vague and nebulous. And you have to really go to innuendo to try to pin the president on this racial animus or this religious-based animus. And I don't think they make the case. But let's say there is. Let's say the president has made statements after inauguration that reflect racial animus or religious-based animus. I don't think that's enough to strike down the policy, specifically because this is a fairly rigorous Article 2 policy where the president did a lot of research and his entire cabinet signed off on it to say we need this for national security. Whether or not we agree with that, actually I don't agree with it, it doesn't matter. This is what's subject to what's called rational basis review. In the foreign policy realm, we don't closely scrutinize the president's determination. We just don't do that. Now maybe I'm wrong, maybe the courts say we need to closely scrutinize this because of the statements before and after inauguration. Okay, then I'm wrong. But under current law, we don't look at it that closely. So in the grand scheme of things, I think it's a very tough argument that the president has to make. But I think ultimately he does prevail. But let's just go now towards what I think the Supreme Court will actually do here. When you're a lower court judge, you're bound by precedent, but in a much smaller way. Because if you deal with a new issue, you don't have to think much beyond your own court. But when you're the Supreme Court and you're issuing a ruling on presidential power, you know that your decision will be cited for decades and decades to come. And whatever rule you make for Trump will apply just the same to President Bernie Sanders, right? Or President Elizabeth Warren. I think the justices will be a little bit more considerate of this fact. Specifically, if we establish a rule that you can now look to campaign statements to inform the president's actions, that is very important and can disable presidents in a lot of respects. And maybe say, wait a minute, Josh, Trump was such an egregious candidate, maybe we should disable him. And in a large part, this litigation is premised on the fact that they do want to disable his presidency by any means necessary. This is legal resistance to the Trump administration. That's fine, right? And they're well within their power to make these sorts of arguments. I don't think they're going to fly to the Supreme Court. I really don't. So there are a couple of narrow ways of ruling in this case that I think may actually be beneficial. And I'll wrap up right over here. All of these challenges, right, are facial challenges to the executive order. No one has actually been denied a visa under these policies. Why? They've never gone into effect. I think all the doctrine in this case suggests that you can't bring pre-enforcement challenges. You have to basically wait to be denied a visa, then sue on it. I think the court can just dump it on those grounds and say, look, this is premature, right? Actually be denied a visa and then come back to us. And at that point, instead of dealing with these sort of class action, these facial challenges, you have a case-by-case basis where there's specific facts that can be adduced. So I think there might be a way of the court just dumping all this and saying, look, this is pre-enforcement, we're at rational basis review, you guys lose. Let the policy go into effect. Maybe I'm right, maybe I'm wrong, I don't know. But I've been saying for some time, and I think I'm probably right, that I don't think there are the votes to strike down this policy. Whether I think it's wise or not, I think ultimately the policy will be held, if not entirely, at least in large part. So I will stop here. Thank you so very much. And my dear South Texas colleague, almost, right? Almost. We'll give some thoughts. So thank you so much.
Well, thank you for having me as well, and thanks, Kevin, for inviting me. As Kevin said, I still teach immigration law a little bit, but I'm actually a political science professor at Texas Southern University, as well as being a practicing immigration lawyer for about 15 years. And so my perspective on it is really going to be a little bit different. I know that this is, so I'm not going to give you a mini con law class, but Josh did a great job with that. So let me first off say, I'm not sure we're as far apart on this issue as I think some would think. There is no doubt, absolutely no doubt, that there is an absolute and almost plenary power to the executive and the legislative to construct immigration law in the way they see it. If the United States wanted to tomorrow say people who were left-handed could not come to the United States, they would be 100% within their authority to do so. No problem whatsoever. So the issue there is not that. The issue that comes into play here is sort of, I think, at several levels. And I'll try to track along a little bit with what Josh sort of outlined, which I think is very good. So when we look at the background of what happened, the first question we really have to ask is we can't take Trump ban 1.0, 2.0, and now this proclamation, which we can just call 3.0 for ease. We can't take them in isolation because we recognize that they are interlocked and really sort of expanding on or minimizing from previous versions of it. So let's talk about what the ban actually is. There are restrictions to specific countries based on a rationale. And the rationale that's being provided is a rationale based on this perception that there is a national security issue. That is the argument that's being made. That is the argument being made by the administration. Now, the simple facts being what they are, the reality is it as a means to minimize the potential threat of terrorist activity. The natural reaction would be, well, let's look at the data in terms of terrorist activity from these nations as they apply to the United States of America. Now, when we do that, we recognize very quickly that those countries really don't fall into play as high-value terrorist nations, right, in terms of terrorist activity in the United States. If we were to apply a test based on terrorist activities, we would probably ban people from Saudi Arabia. We would probably ban people from Pakistan, because those are the largest countries that have provided the largest source material or individuals who would be deemed terrorists. So then we have to, so we peel it back. So we ask a natural question, which is, why are we doing this? And so we'll go back to that infamous December 7th, 2015 comment or proclamation or statement by then candidate Trump, which is we wanted sort of the insightful comments of let's ban all Muslims till we can figure out what the heck's going on. I think it was his actual quote or some variation of that. That's the basis for what we're talking about. right? So then it becomes a situation where we sort of dial forward, is that this is essentially a political policy. And I think the question then is as many executive actions and executive orders are, they're for political purposes, not for necessarily national security purposes. Now the question is that possible? Is that justifiable? Josh alluded to the fact that this is sort of a larger question because there's sort of an attempt to resist, I think you used the terms, by any means necessary, great Malcolm X quote. I would say you're probably a little bit right on that. Absolutely. President Trump has, I think, indicated he doesn't, has created a level of resistance that we haven't seen since probably the first 7.5 years of the Obama administration. So that being said, let's look at a little bit what it was. So the Immigration and Nationality Act, which is a statute, we'll talk about the statutory elements, which Josh is right, nobody in law school really cares about unless you want to take an immigration law class. And then let's talk about the constitutional elements or the question about the Establishment Clause. So on the statutory elements, the Immigration and Nationality Act, the INA, which is what controls activities related to immigration, was originally passed in 1954, but has been subsequently sort of amended and changed and altered in various forms and fashions. Provides a really pretty large, broad authority to the President of the United States and Congress to deal with immigration authority. So this executive order is a variation of that. It is a regulatory element to try to tweak this. Josh's point is 100% correct. The president has the ability to do this. Question is, are there any governors or limitations to his authority? The plaintiffs in this case have argued, and I think rightly so, that there are questions surrounding whether or not there can be a broad discrimination based on nationality. And that's what effectively this policy does. The policy limits specific countries. Now, the rationale for it is really the argument. So does the rationality behind the policy actually solve the policy goal that the executive order is put in place to do? And I would argue it doesn't. And so the statute, what they're using, the statutory authority, I think there's an argument to be made, and it's one of the reasons why the Fourth Circuit and Ninth Circuit have upheld the lower court rulings. Josh is probably right that the Supreme Court's not going to agree with this, and we can probably guess it's going to be about a 5-4 vote, maybe not. And so it likely will, I think this ban will probably go into effect. But I do think the plaintiff's argument is meritorious on this. The other element of it, which is the other big element, which is this Establishment Clause question, the constitutional question. And that is to say whether or not the policy itself is discriminatory on its face based on the sort of the pre-inaugural elements and the political language that was associated with the policy, with the executive order. And to that, I would say, I would agree with what Josh's point is, which is I think it's dangerous to start this precedent where we are going to look at campaign commentary as the basis of policy, as a source of saying. Now, that being said, I'm suddenly losing all my American Constitution Society friends right now. But that being said, I think there are significant questions behind the fact that absent, I think, contemporary documentation through the government, through the rulemaking process, whether or not this is in fact this was constructed to in fact discriminate against individuals based on religion. That's really what the question is. The President of the United States clearly intended to do that on December 7th, 2015. There were subsequent public pronouncements that alluded to that. There was a pullback, and there seems to be, I think, sufficient evidence to make the argument that this is a legal fiction that's been created to essentially cover that up. Now, on a policy level, I agree with all of that. The problem I think we get into is for a court to say all those statements that are essentially campaign puffery and rhetoric, should that qualify? Now, once he becomes president of the United States, everything he says has value and importance. I think sometimes the president of the United States doesn't recognize that everything he says has value and importance. Every tweet has value and importance. Every public statement has value and importance. The problem is I think it's unclear, and there's no legal basis for any statements before. And so that's where I think it becomes a little bit murky. Now, that being said, if you can provide an evidentiary basis, particularly in comments made by Rudy Giuliani, who helped construct this, comments made by the Justice Department on when they helped construct this, there's a reason this travel ban, this Muslim ban, had multiple iterations, because they just couldn't get it right. Now, in effect, I think there's a real question whether or not it's going to actually do anything. Other than, I think, placate elements of his, it really, I think, placates his base and it really serves a political purpose. But as a practical matter, I'm not sure it's really going to limit people as much as they think. As Josh pointed out, we actually don't get much immigration from North Korea right now. Venezuela, there's virtually no limitations, even with this ban. If you have an existing visa from many of these countries, you're going to get to continue it. You have higher levels of scrutiny from many of the countries. So I would argue this is really a giant political exercise, not really a giant legal exercise. But making it a legal exercise, I think, hinders what the president's trying to accomplish from a political perspective.
I actually waived my rebuttal time so I get a little more front, so I think we can go to Q&A. Maybe
Yeah.
I'll weave in some responses to my dear colleagues' comments. So please, questions, raise your hand. Do you want to call people?
Yeah.
Sure.
So y'all both talked about looking into campaign language and then post-inauguration language, is what a court will take into to determine the intent behind the ban. Can you talk more about looking into tweets and how much weight they'll put on the language he tweets out to determine what this ban is?
Yeah, I'd be happy to. So my general position is I think once the president takes the oath, his statement's a fair game. And I see no difference between a tweet, an executive order, a press conference. It's the president speaking through different means. I mean, even like take something like the State of the Union, right? I think it's just pomp and circumstance, right? President Jefferson never went to speak in person. He sent a letter. So I don't particularly care the medium that the president chooses to express himself. The problem is Trump's tweets are mystifying, right? He often makes stuff up and lies profusely, right? Like there was a tweet a couple weeks ago where he said, NBC has bad coverage, I'm going to yank your license. What license? What is he talking about, right? There's no such license that he could actually yank. This thing doesn't exist, right? So it's a person who has a reckless disregard for the truth, and he just makes stuff up on such a regular basis. And he often says things which I think Jay's right are just pandering. He's trying to like rile up a certain base. I don't think that's illegitimate. Presidents get elected by making the voters happy. And I think that's part of what politics is. And even if this order, let's just use a pie chart, right? Let's say this order was like 75% riling up the base, maybe a couple percentages of Islamophobia, and the rest is national security, right? Let's say that's a pie chart, make up numbers. I think it still survives scrutiny, right? So even if he is just doing nothing more than engaging in political exercise, if there's a credible national security interest that exists, I think that's more than enough.
Yeah, I mean, I would agree with the idea that any and all statements made by the president, once he's president, are fair game. And they go to because ultimately what we're talking about, the president can issue any executive order or any executive action he wants. It goes to his intent, because that's what we're really talking about. And so the court can use those external documents, because a tweet is an external document, to determine the president's intent. So if the president is tweeting about the Muslim ban, and or in statements initially saying it's a travel ban, but then said, oh, it's really a Muslim ban, then that's fair game, which is something he did as president of the United States. So all of that fits into it, and it goes to his intent, because I think we all agree, if there's a rational basis for it, and there's murkiness in terms of his intent, I would agree that there's probably not much problem here. But if the rational basis is a bit shaky, because clearly there are countries not on the list that probably should be, and countries that seemingly are on the list that are head scratchers, and you combine that with the fact that there are specific arguments related to religion, that statements he's made, I think you create more problems for yourself.
So you kind of mentioned statutory basis for this and kind of discretionary powers that's been given to Reagan, Carter, they've all used it in one form or another. Do you think the court will rely on Jackson's concurrence in Youngstown to kind of narrow the scope into what powers that Trump necessarily has within this kind of paradigm?
So glad you asked that question. So by the way, everyone knows about Youngstown, right? This was, I think, probably the most important Supreme Court case of the 20th century, one of my favorites to teach. So your college professor should be proud, sir. In this case, President Truman had a crisis. The Korean War was raging overseas, and there was a threatened labor strike at steel mills. And Truman said, oh no, if there's a labor shortage, we won't have enough steel. And if we don't have enough steel, there are tanks and missiles and bombs that we just won't be able to make. So Truman ordered his
big difference.
Yeah, buck stops somewhere. Right. Truman ordered his Secretary of Commerce, Thomas Sawyer, to seize, actually take control, Venezuela style, right? Venezuela, to appropriate the American steel mills to make sure they couldn't go on strike. The steel mill was challenges in court. It raced up to the Supreme Court, and the Supreme Court said to Truman, no, you cannot do this. Now, the opinion, remember this, is not Justice Blatt's majority opinion. The opinion, remember, is Justice Jackson's concurring opinion. And Jackson was a fascinating guy. He never graduated law school, but he went to exceedingly high ranks in government. He served as President Roosevelt's Solicitor General, President Roosevelt's Attorney General. You know, he advised on all these World War II issues. He was a Nazi prosecutor at Nuremberg, and he was a Supreme Court justice. So really, really impressive figure in American history. And what Justice Jackson said is, there are very few guidelines to understand presidential power. We just don't have a lot to go on. So for him, the most important factor is what's the relationship between Congress and the presidency, where, say, the president said, I'm going to do X, and Congress said, you can't do X, right? That's suspicious. And in such cases, we look at it with a lot of very close scrutiny. And then you have a case where the president says, I have the power to do X, and Congress says, we agree, we're giving you the power to do X, right? We agree on this. In those cases where both branches are on the same level, court should be somewhat hands-off. And then there's this murky twilight zone in the middle. This is a case where I think the president's in the first zone. I believe that. I mentioned this earlier, but I think the president has an Article 2 inherent power to deny entry to those deemed dangerous. I don't think he needs a statute. The fact that he has a statute really reaffirms his pre-existing power, which brings us into the first tier of Youngstown, which is why, looking with such scrutiny, I think it's just a simple mistake. If Congress had never enacted 1182F, I think this case could have the exact same way. I do. And let's say I'm wrong, right? But let's say we're in the third tier. You know, the third tier is not a death sentence. You can survive the third tier. And I think this would actually be such a case where you have, I think, a fairly strong Article 2 power. Maybe Congress didn't specify the correct manner of exercising it. I think the president still survives. So under Youngstown, which almost all the justices agree is the framework, and Jackson, I think this order prevails.
Yeah, so, I mean, I know that argument, I think, has been made. And I think the issue, the pushback against that sort of analysis is that while the president's power is absolute, it's absolute in the area of immigration, in its application when it's been given to him by Congress. So if you look at the statute, if you look at the Immigration and Nationality Act, it provides a framework and structure for it. And that within that framework and structure, you don't have the ability to arbitrarily discriminate based on nationality. And that's what I think is the issue here. And so, at least that's the issue that Josh and I were disagreeing on. I don't know that the president could, without the INA do this, simply ban unilaterally. Okay? We're talking about that, that's the difference here. We're talking about unilateral action versus congressional action, or done in concert.
Thank you.
Any more? Okay, well that's about all of our time today. We have class coming in after us today.
Thank you.
I appreciate
Thank you guys very much.